You did your time, paid your debt. Maybe your state even said, yeah, you can have a gun at home again. But then you go to buy one legally from a dealer.
Yeah.
Boom, failed background check, that NICS check. And you're still looking at, what, potentially 10 years federal time under 922G?
That's the reality for so many.
People think, once you're the prohibited person, that's it, game over, locked in forever.
That's a common belief. Yeah.
But is it still true? I mean, has something actually changed? Did the federal government finally crack open a door?
Well, that's exactly what we need to break down. There's been a massive shift. We're talking 18 U.S.C. Section 925C.
Okay, so the mission today is clarity, confidence, truth for folks hit by the system, trying to get those federal gun rights back.
Absolutely. We're walking through probably the biggest change in this area in, over 30 years. It's huge.
All right, let's get into it. 30 years. We heard that door was slammed shut, locked tight. What happened? And maybe first, why was it even shut down?
Yeah, it's kind of wild when you look back. The actual law, 925C, the one that lets people ask for relief from disabilities, it never went away. It was always technically there.
Always on the books.
Always. But, and this is the catch, starting back in 1992, Congress kept adding these little lines to budget bills every single year. Basically saying the ATF, alcohol, tobacco, firearms, and explosives, they couldn't spend any money processing these 925C applications. $0.
So the law existed, but Congress literally pulled the funding. They tied the ATF's hands.
Exactly. Locked the door, threw away the key, like you said. For 3 decades, the federal government just wouldn't even look at these applications.
Wow. Okay, so that was the situation. What's the good news now?
The good news is huge. Early 2025, the Department of Justice, the DOJ, they dropped a new rule. They are officially reopening the process nationwide.
Nationwide.
Yep. And here's a critical detail. It's the DOJ running the show now, not the ATF.
Okay, DOJ, not ATF. Why is that such a big deal?
It signals a whole new approach, a different set of eyes, potentially different priorities. The process is fundamentally changing because the agency in charge changed.
Got it. So just to be crystal clear, this isn't about getting a state pardon or like a local record sealing. This is federal. A federal fix for a federal problem.
That's exactly right. If you get through this, you get what's called relief from disabilities. Fancy term, but it means the federal government officially says, okay, that legal block, that prohibited person status, it's gone.
And that applies everywhere.
Everywhere in the U.S., it's federal relief.
Okay, that sounds like real restoration. But I mean, it can't be easy. They're not just handing these rights back out, are they? Who actually qualifies? What's the absolute starting point?
No. Definitely not easy. And you're right, there are strict rules. The absolute #1 non-negotiable thing. You have to be completely done with your sentence.
Completely done meaning?
Everything. No more jail, no halfway house, no probation, no parole, no supervision of any kind. Finished. Done. The day that supervision ends, that's when your waiting clock starts ticking.
Okay, so completing supervision is day 1. Then you wait. How long?
It depends. Depends on what you were convicted of. The government wants to see proof you've changed, that you've been stable for a good chunk of time.
Makes sense. What are the time frames?
Okay, there are 2 main waiting periods after your sentence is totally complete. First, there's a 5-year wait. That's generally for less serious felonies, things considered nonviolent.
5 years, okay. What's the second one?
The second one is longer. A mandatory 10-year wait.
10 years? Who falls into that category?
That's for more serious stuff. Think drug trafficking, distribution. And here's one that surprises people. Misdemeanor domestic violence.
Hold on. A misdemeanor. Misdemeanor domestic violence gets the same 10-year wait as, like, a major drug felony?
That's right, 10 years.
Wow. That feels intense. Why such a long wait for a misdemeanor, even if it's DV?
Well, from the federal perspective, especially since laws passed in the 90s, any domestic violence conviction, even a misdemeanor, is seen as a major red flag for future risk.
So they want a really long track record of stability.
Exactly. They're demanding a full decade of clean living, stability, responsible behavior. Proof that giving your rights back is safe. It's about demonstrating trustworthiness over a long haul.
Okay, that's critical for people to understand. 10 years for misdemeanor DV. Now, are there folks who just can't apply, like automatic disqualifiers right now?
Yes. There are some definite red flags. Under the current rules, you are what they call presumptively ineligible, meaning basically don't bother applying right now if your past conviction was for murder, rape, terrorism, or felony domestic violence.
Got it. Murder, rape, terrorism, felony DV. What else stops you?
Even if your conviction isn't on that list, you're still out if you're currently under indictment, meaning charged with a new crime.
Okay.
If you're still on any kind of supervision, probation, parole, whatever, or if you have an active domestic violence protective order against you.
Makes sense.
Or, finally, if you're required to register as a sex offender, you need to be totally clear of the system's current control.
All right. Eligibility, waiting periods, red flags, covered. Let's move to the application itself. You said it's not just filling out a form. You have to prove your case. What does the DOJ need to see?
Yeah, the burden is definitely on you. The DOJ is looking at your life since the conviction and trying to figure out basically three things.
Okay, what are they?
1, are you likely to stay out of trouble? 2, are you mentally stable, responsible? And 3, is giving your rights back actually good for the public? Is it in the public interest?
Predict the future based on the past, essentially. So how do you prove that? What's the actual evidence, the paper trail you need?
You need solid proof covering that whole waiting period, whether it's 5 years or 10. It's proof of your life now.
Like what specifically?
Documentation showing no new arrests, obviously, but also things like stable employment history, pay stubs, letters from employers, proof of stable housing lease agreements, utility bills, stuff that shows consistency, responsibility.
Okay, stability documented. What else?
Character letters. These are really important, and they need to be legit, signed, dated, from people who've actually seen your change.
Who should write them?
Think pastors, employers, mentors, maybe respected community figures, people who knew you, saw the mistake, and have witnessed your growth over those 5 or 10 years. Not just your mom or your cousin, needs to be objective.
Right, outside validation. What about your own story? Do you get to tell it?
Absolutely. You have to include a personal cover letter. This is huge. It's your chance to step up, own the past mistake, no excuses, but show how you've matured, what you've learned, the responsible life you live now. Don't let that old record define you today.
Own it. Explain the change. Got it. So you gather all this proof, write the letter. Is there anything else before you mail it off?
Yes. One really crucial step people might miss. Transparency. Accountability at the local level. Before you send that packet to the DOJ in Washington, you must officially notify your local top cop. That's usually your county sheriff, or if you're in a city with its own force, the city police chief.
You have to tell them you're applying.
You have to send them a complete copy of your application packet, everything. And they get a chance to weigh in. They can send their own feedback to the DOJ saying they support it, oppose it, whatever. It's mandatory.
Okay, local law enforcement gets looped in. What about cost? Is this going to break the bank?
Actually, no. The filing fee itself is really low. It's $20. $20.
It says $20.
Yep. But you got to pay it right. It has to be a money order or a cashier's check. Make it payable to the U.S. Department of Justice. No personal checks, no cash. Get that part right.
Money order or cashier's check for $20. What if someone genuinely can't afford even that?
There's an option. You can request a fee waiver. But you can't just say you're broke. You need to include a formal letter of hardship explaining why, and you got to back it up with financial documents, proof of income, or lack thereof.
So options are there, but you need proof. Okay, now, this is probably the most important part where things get tricky. Federal versus state. You touched on it, but let's really break this down.
Yeah, this is where people get tripped up.
Yeah.
And the consequences are serious. Think of it like 2 separate locks on a door. State law is one lock, federal law is another. Your state might restore your rights. Maybe state law just allows possession at home after a certain time. That unlocks the state lock.
So you might be legal under state law to have a gun in your house.
Might be. But that federal lock, it's still shut. And the only key for that federal lock, the only way to legally buy a gun from a licensed dealer in FFL and pass that NICS background check, that's this federal 925C process.
So let's play it out. My state says I'm good. I haven't done the 925C federal process. I walk into a gun store.
You fill out the form, they run the NICS check, denied every single time, because the federal prohibition is still attached to your name in the federal system.
And worse, if I already have a gun, even if my state says it's okay,
you're potentially committing a federal felony. That's 18 U.S.C. 922G, illegal possession by a prohibited person. That carries up to 10 years in federal prison. The state saying okay doesn't protect you from federal law.
Wow, okay. That is a critical distinction. So the bottom line is, for full protection, especially for buying firearms legally, you need this federal 925C restoration.
That's the only way to clear your name federally. If the DOJ approves your application, you get an official certificate of restoration. That's your proof.
Okay. But even with that federal certificate, Still got to check state law too, right?
Always. Always double check your specific state's rules. But getting that federal relief under 925C is the absolute key to closing that dangerous loophole and getting your full Second Amendment rights back nationwide. It's about true freedom, true dignity.
Man, redemption is real. We believe that. God opens doors of restoration that nobody can shut. And this sounds like one of those doors. If you're ready, if you feel called to walk through it, fight for your rights, your dignity, you need a clear path.
Absolutely. And we want you equipped for that journey. To get the resources, the knowledge you need to start this whole process, you need to visit legal-gangsta.com.
legal-gangsta.com.
That's right.
And listen, if you're in Harris County specifically, go to legal-gangsta.com right now, get your 10-step Erase Your Criminal Record Guide. It's going to help you start that journey to freedom toward getting that clean record today.
That's right. If this information hit home, if it was valuable for you or someone you know, please like this, subscribe, and most importantly, share this truth. Somebody out there needs to hear this today.
Yeah, they do. And drop a comment. Let us know your thoughts. Thank you for walking through this restoration journey with us.